Hi, I'm Vicky.
Hi, I'm Keanu.
Hi, I'm Joey.
Hi, I'm Gerjean.
Hi, I'm Renee. And in this video, we're going to be evaluating the green light theory, red light theory, amber light theory, right space theory, as well as evaluating how applicable they are in the current COVID-19 pandemic. So let's get to it.
Yay!
Yeah.
Administrative law is a subcategory of constitutional law which governs a set of rules relating to administrative decisions. The main tool used in this area of law is judicial review. Judicial review refers to the means by which courts can control the exercise of administrative action by the government and other executive bodies. This is governed by the concept of intra vires, whereby the courts must ensure that public bodies exercising their delegated powers are restricted within the confines of the powers conferred upon them by Parliament. Judicial review is only concerned with the lawfulness of the decision made, not with its merits. This is usually judged according to the Act of Parliament, which has granted the public body its power, as well as common law principles. Where a decision is found to be made ultra vires, the court may nullify the decision and require the public body to abide by the correct procedure. Regarding judicial review, the issue to be discussed is, to what extent should the judiciary be able to intervene and correct the administrative process controlled by Parliament? To further understand both sides of this issue, Harlow and Rawlings have introduced a traffic light analogy which subsumes two theories, the red light theory and the green light theory. Besides these, another approach worth evaluating is the right space theory introduced by John Laws. All three theories will be further elaborated and evaluated later, starting off the right space approach. The right space approach emerged as a theory of higher order law. It provides that contrary to the classic model of judicial review, which traditionally regards unlawfulness as a decision made ultra vires, the focus of judicial review should be on the grounds of rights. Here, the concept of rights provides both a legal standard which decisions of the executive may be judged against, as well as a justification for which a judicial decision has been made. Rights-based theorists believe that judicial review is required to enforce such higher order of law, since its main purpose is to perform rights-based justice. However, when applying this approach, the proportionality test must be taken into consideration to ensure constitutional balance. In the case of R. Daly, Lord Steyn stated that when considering whether a restriction on a right is excessive, the court must ask itself the following: whether the objective of a statute is sufficiently important to justify confining a right, whether the measure tailored to meet the objective are rationally connected to it, and whether the means used to impair one's rights are sufficient enough to accomplish such an objective. The merits of this approach include its ability to uphold the rule of law. This is because the theory emphasizes the importance of individual rights, expounding that judicial review should act as a means by which these rights can be protected. Moreover, this theory also stresses the significance of the European Convention of Human Rights, which has been incorporated into the UK by virtue of the Human Rights Act 1998. When aligning decisions to be compatible with the convention, there is a margin of appreciation whereby public bodies can incorporate the convention accordingly without disregarding the purpose of the convention. On the other hand, one limitation that may discredit this theory is the fact that it would give the judiciary too much judicial discretion. Thus, it may be observed that this theory may adversely affect the doctrine of separation of powers. Moving on to the first limb of the traffic light analogy, the red light theory takes an interventionist approach. Advocates believe that judicial review should be implemented strictly to ensure that public bodies only exercise powers within their legal confines. The rationale behind this theory is to protect individuals' rights from an executive's decision made ultra vires. Red light theorists believe that abuse of power is inevitable, albeit usually without malice or bad faith, but rather because government departments may misunderstand their legal position. Therefore, the law must provide the means for this abuse to be scrutinized thoroughly. The theory argues that judicial review would aid in upholding the rule of law, the doctrine of separation of powers, as well as parliamentary sovereignty. It can be observed that judicial review epitomizes the rule of law, as it would ensure that if an executive decision adversely infringes the rights of an individual, the decision must go through a process of scrutiny by the judiciary. Furthermore, judicial review allows courts to check on the legality of the decisions made by public bodies, thus proving to uphold the doctrine of separation of powers. In addition to that, although it is indeed the role of the courts to adjudicate on matters of judicial review, red light theorists posit that in doing so, the courts are merely enforcing the will of the elected parliament. Therefore, it can also be established that judicial review can form an aspect of parliamentary sovereignty. Evidently, judges have shown their opposition to ouster clauses which they have interpreted restrictively. In the case of Annis Minnick, the House of Lords held that there was no difference between errors of law made intra-vires, which had previously been regarded as non-reviewable, and errors of law made ultra-vires. Regardless of an ouster clause, application of judicial review may still persist where an executive has erred in his decision. This conveys the judiciary's reluctance to allow the executive's administrative process to go unreviewed. Despite the merits of the red light theory discussed just now, it has its limitations. The restrictive use of judicial review may hinder the effective mechanism of government, as judges may unnecessarily fetter the government's discretion in decision making. After all, the needs of the people should be taken care of by the elected government, not the non-elected judiciary. Those opposing this theory have since argued that this encroachment of the judiciary onto the territory of the executive may hinder the welfare of the people.
As opposed to the red light theory, the green light theory is inclined towards conferring flexibility to the government when society evolves with complexity. Unlike the red light theory in which the state should be limited to a very limited range of social functions such as law, order, and defense, but not including social welfare or economic regulation, the green light theory has a more positive view of state power. The objective of the green light theory supports the notion that administrative law exists to facilitate the government's needs in achieving certain policy objectives while reducing intervention by the courts. In Harlow and Rawlings, it was stated that the main concern of the green light writers was to minimize the influence of the court. Courts, with their legalistic values, were seen as obstacles to progress, and the control that they exercise is unrepresentative and undemocratic. In order to boost the efficiency of the government's policy making and processes, the courts will step back and reduce their intervention in administrative actions, especially during crisis or war. However, this will not infringe the doctrine of separation of power because the courts are not totally restricted from interfering with administrative actions. They are just less interventionist compared to the normal times. Although it is arguable that this theory might undermine the rule of law and rights of citizens, it is beneficiary as it looks at a bigger picture and considers the society as a whole while making decisions. The green light theorists believe that courts should not restrict or control the state when it is trying to achieve public goals. Public goals include social welfare elements such as health, housing, and education that are beneficiary to the society. In achieving this goal, the executive must have wider powers and the judiciary should at least not slow down the process by interfering too much. There are several situations where the judiciary will favor the green light theory and shows non-justiciability towards the executive. Firstly, it is when the matter is concerning high policy whereby only the executive has the authority to determine such matters. The area of public policy includes foreign affairs and national security, planning sector, financial matters, and so on. One of the cases will be the famous GCHQ case, which clearly states that courts are not in a position to review executive decisions on national security grounds. Other than that, in the case of First Secretary of State and Hammersmatch Property Limited regarding to the planning sector, the Court of Appeal held that even if the judges have different opinions on the decision, they are not allowed to exceed their powers and intervene the decision made. This is because the planning authorities are the one holding the power and eligible in making planning judgments. However, the courts may be able to interfere if the authority has acted ultra vires. In addition, exclusion clauses like ouster clause can exclude the jurisdiction of the court. A successful example will be the case of our Privacy International and Foreign and Commonwealth Secretary, where Section 67 subsection 8 of the Regulation of Investigatory Powers Act 2000 succeeded in preventing judicial review on the decision made by the Investigatory Powers Tribunal. Although the green light supporters favor the political and democratic mechanism, but it is important to make sure that it is in control. Hence, the amber light theory was recommended and has become recognized as a clear approach to administrative law during the election of the Blair government in 1997. This theory confers balanced degrees of discretionary power to the state, not being as harsh as the red light theory, but not being as linear as the green light theory either. Lawrence Bowles stated that the amber light theory is built upon two principles. Firstly, administrative processes must be governed by both judicial and political controls. And secondly, a balance must be struck between judicial review and fundamental needs of efficiency. Besides, the objective of this theory is to safeguard a particular vision of human rights. Over the past decades, the courts have shown a growing desire to apply this approach in judicial review. Now that the Human Rights Act 1998 has come into force, the courts have a powerful parliamentary mandate to act in this manner. Now we have covered all four approaches, and we will move on to apply them to the current COVID-19 pandemic.
Two American cities tonight, Minneapolis and Los Angeles. We'll have more on both situations in a bit.
You can see the pandemic striking there, a very big number of what they call...
That COVID-19 can be characterized as a pandemic.
The COVID-19 pandemic is a war with unseen forces, affecting not only the UK but the whole wide world. Thomas Hobbes emphasized that a constitution which allows a unified government to rule in an unrestrained manner is crucial to combat brute situations as such. From the analysis of the green light theory above, it is submitted that the green light theory may be the most relevant approach in this pandemic. The following section seeks to explain why. Firstly, Article 2 of the ECHR established that everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. Under this provision, a positive obligation is imposed on the state to not only do all that it can to prevent the unlawful and intentional taking of life, but to also take appropriate measures to safeguard the lives of those within its jurisdiction. The context of healthcare is one in which the positive obligation would arise. Furthermore, Article 8, Section 2 of the ECHR also established that one's right to respect for private and family life shall not be interfered by a public authority unless it is in accordance with the law and it is necessary in a democratic society in the context of protection of health. Thus, there is an overlap between Article 2, Section 1 and Article 8, Section 2 of the ECHR. The court stated in Brincat and others and Malra in 2014 that the positive obligation under Article 8 requires national authorities to take the same appropriate and practical measures as required of them in the context of the positive obligation under Article 2 of the Convention. It is important to note that the state's positive obligation are not unqualified. In other words, the authorities are not obliged to take specific measures to avoid the risk of every presumed threat to life unless, number one, the authorities knew or ought to have known at the time of the existence of a real and immediate risk to life, and number two, the authorities are able to retain a certain degree of control over the situation. Applying this to the context of the COVID-19 pandemic, the authorities do have a duty to take appropriate measures as the two elements mentioned earlier are satisfied. The first element is satisfied as the World Health Organization declared the novel coronavirus outbreak to be a global pandemic on the 11th of March 2020. By then, the authorities would have known that the existence of the COVID-19 virus is a real and immediate threat to life. The second element is satisfied as the state is able to retain a certain degree of control over the situation. This is because analysis of the nature of the virus shows that it is transmitted via human to human contact. Thus, the state is able to exert control over the citizens' movement and activities by enforcing regulations such as the Movement Control Order or the interstate travel ban and so on.
Secondly, as the state is under a positive obligations to take appropriate measures in regards to the COVID-19 pandemic, the Health Protection's Coronavirus Restrictions England Regulations 2020, which is a statutory instrument enacted under the Parent Act of Public Health Control of Disease Act 1984, has also granted certain powers to the government as a response to the public health emergency. This includes the power to restrict movement and public gatherings, and the police power to uphold the regulations and the fine which can be imposed. Moreover, due to the urgency of the matter, the Coronavirus Act 2020 had also been enacted via the fast-track legislation. It had been passed in this manner in order to efficiently grant the government emergency power to hamper the spread of the disease. Some of the main powers granted under this act includes the power to instruct anyone to appear to a coronavirus assessment and screening center, and also the power to shut down educational and childcare facilities, while making it an offense for anyone who disobeys these instructions. However, several issues seem to arise by fast-tracking the Coronavirus Act 2020. Firstly, it is arguable that the doctrine of separation of power may be infringed as the Coronavirus Bill was passed through the fast-track procedures, which received royal assent after merely 6 days it was introduced to the Parliament. This is because fast-track processes are usually dominated by the executive, where they more or less control the Parliament's legislative agenda. This may symbolize an encroach upon the legislative territory, which is against Montesquieu's belief that the separation of power in the UK is to ensure that there is no abuse of power by any person or body. Nonetheless, it is indisputable that the urgency of the current situation renders it constitutionally acceptable for the Coronavirus Act 2020 to be fast-tracked and extensive power to be delegated to the minister so that the government can respond effectively.
Next, constitutionalists have expressed another concern that emergency legislation having passed through fast-tracked procedures are often given hasty or inadequate parliamentary scrutiny. It could then be difficult to be abolished from the books as it becomes part and parcel of the legal framework. Therefore, the sunset clause under Section 89 of the Coronavirus Act provides most of the Act to expire 2 years after its passing date. In general terms, a sunset clause is a measure within a statute which specifies the date of automatic repeal of the law, unless the legislature takes action to renew it. Such provision is effective in restricting the duration of substantial power. This signifies the Parliament's intention to strike a balance between conferring extensive powers to the government while ensuring that the said powers are not prolonged unnecessarily. However, such a significant fast-tracked legislature, having an operational lifespan of 2 years without reapproval, could be too long. The government then agreed to accept the requirement that the Act is to be reviewed by the Parliament every 6 months, allowing MPs to express their views and vote on the continuity of the Act's provisions. It is then arguable that the 6-month time frame between reviews could be too infrequent. In the 2009 House of Lords review of fast-track legislation, Lord Baker was in favour of post-legislative reviews being carried out reasonably quickly afterwards to monitor the effectiveness of the legislation. The Better Government Initiative further emphasised that post-legislative scrutiny must be done much more frequently. Therefore, considering the nature of the crisis and such degree of radical powers being afforded, far more ongoing scrutiny may be required. However, can it be said that the rule of law is infringed due to the government's extended powers to restrict one's freedom and rights? A deeper analysis will be conducted under the rights-based approach.
Although there is a positive obligation under Article 2 of the Convention for the state to take specific measures when there is a threat in public health, This does not mean that the state is allowed to impose any regulations as they please. WHO accentuated under Article 3 of the International Health Regulations 2005 that measures imposed must be in respect of human rights, dignity, and fundamental freedoms of individuals. The importance of protecting human rights are further stressed on by both the Yuen Committee on Economic, Social and Cultural Rights General Comment No. 14, 2000 and also the International Covenant on Civil and Political Rights, ICCPR 1976. Regardless of how hectic and strenuous it is to take into consideration conflicting interests, especially under conditions of scientific uncertainty and crisis, the rights-based approach is of the notion that the rule of law must be upheld at all times. Furthermore, the Universal Declaration of Human Rights also stated that all human beings are born equal and free in dignity and rights. The state's obligation to safeguard the lives of those within its jurisdiction does not only apply to regular citizens only, but it also applies to the minorities of the society. Therefore, it is vital that migrants, refugees, and homeless people are ensured equal access to health services. Similarly, the state's obligation also encompasses a duty to take preventive operational measures in the context of prison or detention in custody. The UK government had been working closely with public health and NHS services to enforce sturdy contingency plans to manage outbreaks of the disease in prisons. Temporary changes have been made to the usual regimes conducted in prisons as well. In order to practice social distancing, prison inmates can no longer participate in recreational activities such as going to the gym or worshipping together. Through the various means of the UK government, it can be assured that the right to health of prisoners are being upheld during this COVID-19 pandemic.
Although Article 15 Clause 1 of the European Convention of Human Rights and Article 4 Clause 1 of the International Covenant on Civil and Political Rights allow for derogation of certain human rights during the time of public emergency, actions taken by the government must still be in accordance with the law, in pursuance of a legitimate aim, and proportionate to the circumstances at hand. The Siracusa principles would be the most relevant to be used other than UK case laws, as it is an international law which consists of well-established proportionality principles developed and adopted for public emergencies such as the current pandemic, whereby restrictions are likely to impact upon the nexus of different rights and freedom. Article 11 of the principle states that in applying a limitation, a state shall use no more restrictive means than are required for the achievement of the purpose of the limitation. Strasbourg jurisprudence also supports the application of such specialized international instruments enunciating recognized norms of international law, which may therefore be applicable to the UK as well, according to the Section 2, subsection A of the Human Rights Act 1998. According to the official statistics by the government, the actions of the UK government thus far seems to be justifiable and necessary in order to achieve one of the main objectives, which is to hamper the spread of the disease. Moreover, these actions are supported by the Scientific Advisory Group for Emergencies, also known as SAGE, who provides ministers and officials with evidence-based scientific advice in the emergency, ensuring they are informed and best placed to make critical decisions. Therefore, this may suggest that the government's actions is in accordance with the rights-based approach, as relying on SAGE's advice before taking appropriate measures ensures that the regulations imposed are proportionate with the current pandemic situation. Furthermore, the courts are slow and reluctant to intervene with the authorities' decisions when the government is relying on medical experts' advice before deciding on the implementations on the rules and regulation. This could explain why the red light theory is not relevant during this pandemic. Moreover, the government's discretionary power during the current situation may arguably be wider when balancing competing rights and interests. This is due to the fact that public health is recognized in law as one of the highest of all public interests, and the margin of appreciation is particularly broad, where the objective of a measure is the promotion of a benefit of such great general importance. This further shows that the green light approach may be the most suitable, as the court will have to give way to the government in order to overcome this situation.
Despite social distancing restrictions affecting physical court hearings, judicial review remains operational if the regulations imposed by the government are disproportionate to the current situation. Section 53 to Section 57 allows the usage of remote technology in court proceedings. The protocol regarding remote hearings was released in March as a guide for remote hearings, including the usage of audio and video technology such as telephone and Skype for Business. In fact, the Supreme Court had its first ever remote hearing on the 24th of March, as the Supreme Court building is now closed until further notice. In the meanwhile, all of its hearings and judgments are to be heard and delivered via video conferencing. Therefore, it is crucial that the powers in the Act are well regulated so that an efficient court system remains in place for citizens to challenge excessive use of executive power. Furthermore, the Delegated Powers Memorandum contemplated that the Parliament might not even be able to sit up to 2 years due to the current physical restrictions. This leads to the risk of inadequate scrutiny of the government, as MPs not being able to attend Parliament means that they are unable to utilize all parliamentary tools at their usual disposal. For example, MPs cannot raise oral ministerial questions during a recess, and this carries huge consequences towards the ability to scrutinize and question ministers about their exercise of powers and policy development, which changes daily. Therefore, the judiciary now plays an even larger role to scrutinize the executive by judicial review, allowing checks and balances to continue taking place. In conclusion, the green light theory suggests that courts should minimize intervention on administrative actions in order to facilitate the operations of the state. The red light theory takes an interventionist approach that judicial review should be implemented strictly. The rights-based approach is of notion that the rule of law must be upheld at all times. The most relevant theory during the pandemic appears to be the green light theory. Although the government is indeed granted broad powers, the sunset clause, parliamentary scrutiny, administrative and judicial oversight are safeguards to uphold the rule of law. A joint effort between the Parliament and the judiciary is vital to ensure that the government's powers, while of significance to the country's well-being, are utilized proportionately by periodic reviews and judicial review. As mentioned above, judges have been more inclined towards the amber light theory during normal days, because strict application of red or green light theories could cause extreme consequences. Hence, the amber light theory may come into effect after the pandemic is over, as the Parliament looks for a direction to put things back into place.